And for more perspective, we have with us a cyber and tech law expert, Advocate Shivaarti Bajaj. Advocate Shivaarti Bajaj, thank you very much for speaking with RT India.
Thank you, Sam.
You know, for many years, the social media platforms, they have argued that, look, we are just intermediaries. Now, what we are seeing today is that the courts, they are increasingly questioning not just the content on these platforms, but the way that these platforms are designed. My question is, are we looking at a new legal standard for big tech?
That's a very valid question. In fact, what you point out is something what we call as the law shifting from mere form to structure. With the advent of AI, with the advent of big tech holding so much power, India currently just stands with the IT Act. Now, the IT Act has been amended periodically to cater to the current situation of the use of the platforms in terms of the present problems that arise from it. That takes us to the present situation where, in fact, it would be very interesting to know, and as the gentleman earlier also mentioned, that the intermediary rules have been brought out in as quick as February this year, and which were implemented within a very short span by the government, again targeting directly the intermediary, significant intermediary platforms, if we can have to technically call them, because they hold a lot of user information, millions and millions of users on the platforms. So this is something that has come into light. Now, in view of these rules, to answer your question more specifically, yes, it is coming directly to the law getting not only changed, not only amended, but also implemented in the right manner. What Meta is taking right now is the argument of they being a safe, they're taking the argument of a safe harbor, which is coming into direct question in line of what has presently happened in terms of the video of our Honorable Prime Minister being taken down without any reason, without any intimation to the opposite party, without any email or any form of reasoning. It's something that puts them directly in question with the safe harbor that they have been taking till now.
Shivaarti, you know, Meta will say that, look, billions of people, they use its platform every day. So no company can actually monitor everything that is there on the platform. And hence you have these algorithms monitoring things. Now, the thing is, if these algorithms, they recommend harmful content, if they repeatedly push it to the users, does that change the company's legal responsibility then? I mean, where does the legal responsibility really begin?
The legal responsibility for an intermediary begins now, as we stand now. Earlier, intermediaries were quite shielded to a very great extent, stating that we are a mere connecting platform between a user and a consumer. But with the advent of the current rules that have been amended over the years, the shielding has been diluted to a fact that it has at least come into question in terms of reasoning. Especially the amendments that were made very recently, Osama, those actually bring in light the fact that they are even catering to the synthetic content being put on the platform, which for easier understanding is your AI generated or generative AI generated content, which now the intermediary platforms have to clearly mention that such information has been artificially generated. And the platforms very much have the tools to assess that. So something like either a watermark or a small heading on the image or the content stating that this particular content is AI generated. Things like this were not earlier existing. And when I say earlier, I mean as recent as few months and weeks from now.
Yeah. So as we stand, Shivaarti, you know, Meta, from what I understand, Meta can't really hide behind this argument that, look, we are just a platform, because that has been the company's strongest legal response.
Yes, this argument has come into question big time, especially the fact that the argument that they've been taken till now, that we are of the safe harbor, that has come into being revoked. If sufficient reasoning is not provided.
Shivaarti, do you think this is a compliance issue or is it a design issue? Why I say this is because, like I said, for many years, regulators, they focused on taking down harmful posts. Now, the entire spotlight, it is actually shifting to algorithms. It is shifting to recommendations, engagement-driven design, etc. Does that also require an entirely different legal framework then?
It does require an entirely legal framework, but our current IT rules at least are robust enough to deal with a problem such as the one arisen right now, for a very simple fact that under Section 79 and especially read with rules 3 and 4, the fact that the single point of reasoning that is coming from Meta is that they are using the aspect of being a safe harbor, which is coming into question basis the current law.
Yeah.
Of course, as we move ahead with technology, with usage, user behavior, user conduct, the laws are going to be amended. There are new laws also in picture that are underway and under discussions. The drafts are being discussed, such as I'd like to bring to your knowledge that there is a paper being discussed of AI and copyright by the relevant ministries as we speak, which is dealing with direct consumption of content on AI platforms. So very active work is happening on that aspect. But if
Shivaarti, what would you say is the biggest legal loophole today? Very quickly.
A legal loophole for who? Which party?
I mean, if you had to identify one gap in the current law, what would it be?
The gap in the current law in terms of the current IT Act that stands is the intimation of
I mean, is it also the protection?
Situation.
Is it also the protection that is being given to the intermediaries? Is it the lack of the algorithmic transparency? Is it the absence of personal accountability, especially for all the senior executives? What exactly is it?
It is a reliance on algorithms and AI as a reasoning, which needs to be dwelt more deeper into, because relying on that cannot extend your safe harbor as much as because a safe harbor, if revoked, it exposes you to the BNS and other acts. So then you become exposed to other liabilities and procedures. So that is a kind of loophole that I think, but it is now, even that loophole is subject to answerability as we speak.
All right. Shivaarti Bajaj, thank you very much for speaking with RT India.
Thank you.